Jack. I hope you're okay. This is Richard Kelly. I just wanted to say a few things about the matters that you'd raised around the application for this certificate through the Parliamentary Papers Act 1840. So, I only just found out about that act recently. So, there was other legal bases to apply through and using. I chose that because I believe that Lord Denman, when he proposed that act and got it put through Parliament, that he understood that anything that has been warranted or given the process to run through government really is a parliamentary paper, including petitions. When someone first writes a petition in their house, if they do it on paper or by internet or any means, it's hard to tell that it's an official government document or process. Once you submit it and anything gets actioned or warranted, then it is, but you have to be able to submit it and start it in the first place. As soon as you go on the online petition website from the very start, as soon as you fill the form in and then create the petition to collect the first 5 signatures, it immediately gets the Crown stamp on it. So it's at least warranted to get the 5 signatures before it can run live to collect a large number of signatures. The petitions are evidence-based. It's an evidence-based process. Really, there isn't really anything to distinguish it from a criminal or civil case. If you are really interested in this, and if you're really interested in petitioning the government, right, I've just read, not the entire archive, but Dr. Brodie Waddle has got about 2,500 petitions transcribed from handwriting into type, a very large number of them, so you can actually search for terms. So I've actually got I've got his entire collection of petitions, so I've been reading through a lot of them to find out what situations those people were in, what they've been doing, how the process worked, and a lot of surrounding circumstances around them to gain an insight into the period of time they were in, and a lot of the legislation that I've read pairs up with how the procedure changed through history. I mean, this talk could end up being really long because there's so much things to explain and understand. There is so much information and details to understand about it. But really, you have to start with the Magna Carta and the sheriffs. And it's explained that when they created the whole process, when you go to a sheriff, you're making a complaint to the king about someone's behaviour, and it is a complaint petition. And when you hand it into the sheriff, then he warrants it, and then you have to apprehend the persons, but you need some kind of evidence in the first place. If you don't have any evidence, you can't prove that they should give the warrant to arrest the person. And really, how we see the whole system now, how the average person looks at it, is a little bit deceiving. There's not really too much difference between the criminal and civil process. In fact, they were very, very indistinguishable in process for a very long time. Both civil and criminal, if someone owed you money or if they'd committed an offence against you, you could get them arrested, and they would be arrested and then go on trial. And you could do it. You could go to the sheriff's office and get, you have to show them some kind of evidence to substantiate it, or they're not going to issue the warrant. And then you would go arrest the person or fine them, or using the writ, the warrant, or get some people. Sometimes the whole town had to go find them once the warrant was issued. This is where the wanted posters go up all around town. If that person's wanted, and anyone has a warrant to arrest them. But also for civil as well. There wasn't any difference in the process, in the warranting process. Really, it was a different type of case, or a tort case, because you're only usually retrieving money or having a decision made. Whereas with the crime, the person's going to be have to pay a fine or have a certain particular sentence. But you need to be able to turn up with some evidence to substantiate any claim on any writ. And if you don't have any power to do that, you can't do anything. Now, really, the sheriff and the under-sheriff and the constables and the bailiffs, it's true they had all these positions, but there were very few of them, right? And the public actually traditionally are meant to be engaged in that process. And really, I mean, women, for example, usually most women don't want to, have to do anything heavy-handed. So, I mean, if a woman brought a complaint into the sheriff and it gets a warranted, or a very old man or something, they're probably not going to be able to apprehend or bring in the person themselves. But there is a right for the citizens. Most men can or could, and take them into the sheriffs. That's what it explains on the George Cook writ that I showed you. That he's giving warrant to Radcliffe and Baldwin to apprehend Tillotson. So, but usually the sheriff would do it because it's just like, a bit of a heavy-handed thing to have to bother to do. A lot of people might not want to have to arrest someone and grab them and bring them in, but other people might have been more up to it. But that's what the process is. It's meant to be the public engaged. And, now we've got the police to deal with it, so most people don't bother. But there is a legal right to citizen's arrest. Now, when you draft the original complaint in order to hand it to the sheriff to have it warranted for any case or cause, even if there's no person to be arrested, even if it's just a case with some evidence, and then you arrange a court date, the whole petitioning the king is, it explains in the start of that, the very first statute law compilation, it explains that when you go into the sheriff, he puts the king's seal on it, because it's a king's process. It's the king's process. The sheriff is the king's process. The civil court is the king's process. It's all the king's process, and the foundation model of it is king and council, the privy council and the king. So, with this, to start the model off, how we draw the framework up, there is only the king and council, and then he's got his sheriffs around, okay? Now, if it's anything to do with a complaint about a judge, or a complaint about a sheriff, or if you want taxes changed, or any case with a writ, the writ for the criminal complaint is exactly the same form if you go back as the petition. I humbly showeth, you're presenting evidence, and then when the prayer is what you're asking for, and the oath is the signature that you're saying it's the truth, and you can put a little statement there if you want, a statement of truth, or sign it, and who it's addressed to, what department of the king's division is it, the sheriff, or a justice, or the king himself, or his privy council. That's how the whole thing's set up. Now, there isn't, to start the model, there is no parliament and there are no MPs. So it's all directly to the king or through justices. And then if the justice doesn't agree with you, or if the justice is not upholding the law or disputing the law with you, That's why they brought in the Statute of Westminster II, that Bill of Exception, where you can actually effectively are petitioning the king and arguing with a judge, and you're actually summoning the judge. We've got the right of summon, right? If I have got a case or cause with any justice in any court, right? The Bill of Exemption summons the justice to the king, right? So it's actually compelling him. You write out that you don't agree with the justice on. It has to be on a point of law, though, or a right that you're being denied, and it actually compels the justice to have to go to the king, and they have to get the law out and look at it, and then get back to you on it, and that is still in law in the Statute of Westminster II. It is a very extremely important law that is still in force. And what it does is it makes sure that if you're being denied a right or arguing any point of law and it's been lied about or denied or they're wrong, you can summon and compel the justices to the king. And that's actually where the 1688 Bill of Rights, the basis for it, really is based on that. That's the truth and fact. Way before 1688. Now, as we go on, then they start calling parliaments, right? And when they call a parliament, it's the commons people who've got a right to petition the king and a right to have grievances and request for laws to be changed or taxes. But we elect representatives to go do it for us and turn up in parliament. So parliaments were held every so often. Now, if there is a parliament, okay, and if you have elected someone, you don't need to petition the king and council because now there's a parliament and the parliament operates under its privileges and rights. So you don't need the right to petition the king, and all prosecutions are illegal, although that came later, but it's only a reaffirmation, okay? You've always got the right to submit a complaint and get a warrant, whether it's a criminal or civil, or in a matter of the state, a matter of the country, a matter of the nation, raise a case to the king. But that case, it has to be an evidence-based process. It is process. It's process through government, okay? And all what happens when you get a parliament is that you've got a body who's dealing with the king's business, and then you've got the two houses, and you've got your representatives who are going to act for you. But those representatives, right, if you think, okay, they're meant to deal with all the matters of a certain ward or area, an electoral area, right? But, okay, you are channeling everything through the MP, but you don't have to because they've got a petitions committee who deals with petitions, okay? The MP doesn't just only deal with petitions. The public have got a right to petition the petitions committee directly, not channeling it through the MP. Otherwise, the petitions committee, it wouldn't have a committee. It would all be through the MP and just their surgery, and it would be a website just for one MP surgery, and it has to go through the MP. Every single MP in England is not in the petitions committee. It's one committee focusing on the petitions, so everyone's got the right to petition the Commons because we don't need to petition the King and Council because that's why we've got a Parliament, so the King and Council doesn't have to deal with the petitions, and also why there's a petitions committee, so the MP doesn't have to deal with all of the petitions if there's a very large number of them. That committee is solely dedicated to petitions, although the MP has a right to put them before Parliament and put them in the bag and read them out when it's from their area or place, but also the committee. But what is the process? The petitions committee process in the Parliament that has been called and people have been elected to it is the very same petition process that otherwise you would do to the King and Council. But now the petitions committee has taken that role, and Parliament operates under privileges, just like any court does. When you're bringing a court to when you're bringing a case to a magistrate's court, there actually are privileges of the magistrate's court. When you're bringing a case to a Crown Court, you've got privileges of Crown Court. A magistrate's court cannot make judgments or intervene in a Crown Court procedure, and so forth with the High Court. A Crown Court or magistrate's court can't intervene in a proceeding for the High Court. It's process, it's writ and process, and when you read it all and understand it, in 1688, when it was merely a reaffirmation of the existing principles, people are using and asking for privileges all the way through the 1600s, way before the Bill of Rights. I've got that in the process. I've got that in the petitions. They're using it. There's a Parliamentary Privileges Act of 1620s. But they didn't always have a parliament in the 1620s, so no one would have privileges of parliament. In 1620, there's a Privileges of Parliament Act, but no one is going to have parliamentary privileges when they haven't called a parliament. So it has to be directly to the King and Council, and that goes for everyone in England. If you can't collect... What if a sheriff's done something wrong? If you have not got a right to collect evidence on a sheriff, right, and submit that evidence by writ and process to the King and Council or against the justice, then you haven't got a right to anything. And that justice's process is covered by that Bill of Exemption. And it actually summons them. It summons them to the king, and you've got to have something written down on there to evidence-based to summon them on, which is usually the dispute you'd have in the court. But you've got a right to complain about a sheriff directly to the king. It doesn't have to be to a court or the justices or anything if you want the law changed. But how do you prove you want the law changed? I think Parliament know it's an evidence-based process. It's process. It's writ and return. And written return is always, it is an evidence-based process. And on the petitions website, all through history, they're attaching and annexing evidence to petitions. They only made a resolution in Parliament a lot later on, more recent history, where they said, oh, it done annex evidence to it, because it was getting hard to organise it all. And remember, a lot of the petitions got burned in the fire of Parliament, and then they stopped saving them until 1947. They weren't even saving the petitions that didn't get read out. They just destroyed them all anyway. They made some notes, apparently. There is a record on a microfilm somewhere of the evidence, at least some kind of basic notation of the petitions, which I want to get that. It's available somewhere on a few research websites. So they only stopped annexing evidence or sending evidence or attaching evidence in later on. The more evidence you've got, the stronger case you can prove about anything. It doesn't matter whether it's a tort case or a criminal complaint or a grievance with the government. With no evidence, you can't prove anything. Now, the signatures really are the witnesses, or anyone who can vouch for what you say is the truth. And also, they've got this thing where if someone can vouch for your behaviour or good conduct. Now, they make an act from the 1688 Bill of Rights onwards in those preceding 4 years, which explains that you're entitled to a pardon if, a dozen people can vouch for your good behaviour in writing with their oath, and that can get you a pardon. Now, if you've got 6 persons signing your petition and they say, we vouch for your behaviour, that you're a good person, but we need to do this, get this evidence or do this process, and it needs to be done in order to present to the government evidence, that's the basis for the pardon and the vouching of your behaviour and conduct and character by other citizens. That's in one of the acts that was put through around the time of the 1688 Bill of Rights, just after. And that act, it's based on the Magna Carta, the judgment of your own peers, right? And that Magna Carta basis has kept the whole way through, right? And they're doing that act. It's a little example. That's only one little part of the right to petition basis. Your signatures and the oaths of other people vouching for your conduct and saying that we had to do this to get our evidence. If it was over 20 persons signing and engaging, that's why they brought in the 1661 Tumultuous Petitioning Act, and it had to go to a court because they're like, oh, just a minute, there's quite a lot of people here who are going to be claiming privileges, all right. So it had to go through a court for them to authorise a very large number of people to support and sign the petition and engage with it. Otherwise, it was only under 20 people. But those under 20 people are the people who are vouching for your conduct and behaviour. This is the problem that William Penn had in the very famous William Penn trial that is at the Old Bailey, which is very extensively studied and researched. I've actually got the full writ for it, the full proceedings in court, which actually have got the full dialogue. That's the problem they had, because they were getting people to subscribe to a cause in the street, but they didn't have authorization through a court because there was over 20 people, and they were accused of a tumult, which is basically petitioning without consent with large numbers of people. But the jury decided that they weren't actually doing a petition, right? And this is actually a similar problem to Alison Young and this group of people who were in Tooting promoting the Stop ULEZ petition cause. They were in the very same position as William Penn and William Mead were in. In fact, the jury said that they weren't doing a petition at all. They were just talking to people in the street. So it can't have been a petition to the King or Parliament. So they weren't even doing a petition, so they can't have been breaking the law of that act. Okay? Because they weren't getting people to consent to something without permission, right? It's an actual amazing casework study, is that William Penn case. There are so many convergences of law in there, and which make it, there's very important reasons why it's an important study case. And this is the thing with Alison Young and this 2 in 5 group of people that they've been called now, who are advertising Stop ULEZ near Sadiq Khan's house. Because if they are doing a petition, and that's what they're doing, they do have the privileges and the right to petition. If they weren't, and if that isn't, and that's not what they were doing, then they don't have that right and privilege. But they actually were. Now you might say, well, what about all these, the Public Order Act and these dispersal orders, and generally all these new protest laws? Well, actually, when Priti Patel and the other MPs did these laws, there's been a very, very recent, well, in the 1980s recent, I'll say recent, I'll call the 1980s recent, really, modern history, right? When the miners' strikes were happening, they started doing all this picketing, right? The word picketing actually means to put up a defensive wall or protective wall. It's not actually people who are complaining. It's not the miners who are complaining. The word picket is for defensive or protective wall. Now, really, Parliament has a picket around it permanently because you've always got the potential of people, the people rising up, right? So the word picket line is more appropriate for something that would be around Parliament, surrounding Parliament, because that would be like, the protective wall around Parliament in case the public kick off. So that's what the picket line means. But in matters of church, state and law, people have the right to petition, and they're not supposed to be allowed to be arrested or prosecuted. Now, that's only like a young 16-year-old child has got that privilege all the time from being arrested. And And also with that Public Order Act, which is why I mentioned young kids, because young kids can't be moved out of the area or arrested. So if you've got the right to petition protection and parliamentary privileges, you're really privileged, just like a child's privileged for being under a certain age, but you're privileged with having a special right because it's a serious matter and concern. But you might say, well, what about all these protest laws? So the truth about the protest laws is that when they did the picketing in the miners' strikes, it's a grievance between an employer and their staff to employer. So all the employers are actually protesting outside their workplace with their employer that they won't go to work or they're not going to work. Now, that is not a writ evidence or a case to the government of a matter of a church, state, or law matter if they're assembled to say we're not going to work with their employer. That is a grievance between the employer and the staff. So you haven't got a matter of church, state, or law to the government in that situation. And another really good example of this, which I can give, which is a very, very valid example. It's a very important example, and that is if you've got a music gig like Oasis, right? If there's a music concert on and there's a band playing some music, and let's say there's an incident, a fight or an incident, and everyone has to leave, the police turn up and tell everyone to leave the arena. They might not want to leave the arena, but it's a matter between the police and the people for the concert, the concert arena and so forth. They haven't got a dispute with the government over getting a law made or changed, or evidence against any particular. It's not a grievance. It's not a matter of church, state, or law. Put it that way. It's a matter of like a leisure facility that has got an incident there, and the police are removing people. Now, if those people want to protest against the stadium with the police there and say we want to go back on the stadium and listen to the music, that's not a matter of church, state, or law that anyone's taken it with the government. That is some people who are protesting, who want to listen to some music and are complaining to the police to let them back on the stadium, right? So if you can use that model and expand that around, like, say, for example, you can have a marathon in the streets, or a cricket match, or there are a very extensive number of situations, a business meeting, anything that's not a matter of church, state, or law to the government, basically, or not a petition to the government. Everything else except a matter that you've got directly through or with the Parliament, or possibly even a legal case. Now, you might say, well, what happens if there's a police officer investigating a crime there? Well, that's the thing. It's the police who are moving people off, and police officers within the force might have, obviously, if you've got police officers moving people off a site for safety, will they let other police officers on who are investigating other crimes besides that incident? Well, there might be another piece of evidence for a different case, non-related, and the police might be investigating that. I would suggest that the police officers turn up, they get their badge out and say, I'm with your force, and chief says that I can go on here. I would presume that they would be let on. That's a very good example when we're going back to what I said earlier on about the Magna Carta and getting a writ with the sheriff to investigate a case or apprehend a criminal, when we were supposed to be engaged, and we always have got the right to be engaged in any civil or criminal case, which is usually always our case that we're bringing. It's always our case if you're the victim or the plaintiff. So let's go back to the Parliament matters. So all that, when they're talking about protests in the law, in the legislation, it's quite misleading, because you can have many, many protests that aren't using rights, English rights, 1688 Bill of Rights, right to petition, where all prosecutions and imprisonment is illegal. It's very, very important. It misleads the public. And I just want to say at this point, I don't really want this video to be too long, but I think that this video needs to be listened to, and in like sections, even like a piece at a time, if you have to think about it and understand it, to make sure you understand it fully and soak it all in, because this concerns everybody, and Parliament and all the other applications that may or may not be entered or granted. So I'm making this video, it's not just like for me, it's actually quite important for everyone. So that's why I think that it's important, why I'm asking that you know, Emma and Helen, yourself and Jack, listen to it and understand it, and not think, oh no, if the video is too long. I mean, I haven't even got to the main things I wanted to say, but it's an important claim at a high level, and it's important to get the legislation right. I do know all of the legislation, all of the clauses quite intimately, which I can discuss any of the clauses in great detail and have a thorough explanation around how that might work and why it might work, and what it's supposed to do. So the legislation is misleading, and what's happened is they've superimposed or misconstrued the word protest when they're doing these public order acts and so forth, to make sure it applies to anything and everything, when it doesn't. It can't apply when you've got the right to petition, because you can't be arrested or prosecuted. So what can they do? Well, I would suggest that, you know, just what would they do if there was 100 small children under 16? If there were 12, they wouldn't be able to arrest or prosecute them. But if they were in danger, they could move them to safety. They're allowed to do that. I would suggest that, because there's a real situation that certain individuals have got the privilege of being under a certain age, there's also the situation where certain individuals have got the privilege not to be arrested or imprisoned because they're engaged in matters of church, state, or law. And that's just the way it is, just the ways that certain people are under a certain age. And those persons really can't be arrested. Well, what can the police do? Well, they can make a picket line. That's what the word picket line is meant to be. The police could make a picket line and protect the area just by force, but not arrest anyone or imprison them, but still, make a defensive or protective wall, a line. Or certain people might claim they're right and say that, well, I'm collecting evidence. Well, this is the argument people have got now with trespassers. Black belt barrister, a highly esteemed and well-known lawyer, is arguing that really, if anyone's in the law at the moment, if you have got a YouTube channel and you're doing certain media, in law, you qualify for those definitions that you're doing it and you've got a right to film certain things. But currently, the police aren't letting people on without a union card, a journalist union card or journalist organisation members card. When you don't, Black belt barrister, who's a YouTuber, a lawyer, a high-ranking barrister, he says that really in the law you don't need that card. This is the thing. A police officer will be able to go onto one of those sites by showing his badge or with orders of his chief, right? If at the very bare minimum, at the very least, if it is a parliamentary matter and a political matter, we have got the privilege not to be arrested or imprisoned. Whether or not you want to argue whether the police can still move people off or out of the way is another argument, or whether you've got a right to go on there and get evidence. What happens if you're getting evidence against the police? That's another argument, but we're not dealing with that at the moment. What we're dealing with in the Tooting incident with Alison and her friends is where only contesting that they shouldn't have been arrested and they can't be imprisoned. We're not arguing whether or not they can or cannot be moved away from the area, as if like someone would move a small child. and get them out of the area, whether or not they've got a right to be there or not. I don't think that you could completely block an area, because by law you've got to be able to poll an area. In law, there's a legal right to be able to poll an area. The police can't stop the government having a polling station or polling an area of people. And if there was something that bad in that area, like, smoke or noxious gases or an earthquake or whatever, they would just have the polling station somewhere else, right? But we're talking only about arrest and imprisonment, not about being moved from any areas or not physically and being put somewhere safe and not being arrested. I'm not disputing that. That is a different argument. So, now, so, and but there is, if you're doing a petition and if you're collecting signatures and letting people know about it, you, similarly to the polling station procedure for elections, the police cannot permanently stop or really stop people from petitioning that area, which is getting signatures, because otherwise they would be saying, like, we're preventing you from getting signatures from these people in these shops or this area, or letting them know about the petition. And that's illegal, because what the police are doing then is the police are affecting or intervening in a process, in a written return of a process, which is to lodge a petition, collect the signatures, and tell people about it. That's what the process is. The police cannot intervene in it. And it even says I've just got a new book through today called The Complete Sheriff Handbook. It's a very, very good book. It's quite an old book, and it's got all the laws for sheriffs in there collected together. It wasn't easy to get, although I did get it for quite cheap. But in that book, they're saying that sheriffs aren't allowed to intervene in other processes, in other legal process, particularly ones for Parliament, whether it's MPs who are privileged or people who are doing it. They're not allowed to arrest priests. There are actually certain rules and regulations for religious congregations, the clergy, if they're having a congregation, and other things. There's a long list, privileged life peers and so forth. Now, I know the laws change, but I'm on certain points, but I'm just setting out the model and basis, because the petition is always evidence-based. It's an evidence-based process. The online petition site, as far as I know, there isn't an act of law for it. And the only legislation around running petitions is standing orders, the standing orders of the Petitions Committee, and how they're presented inside Parliament once they're debated. And there are some resolutions. There are some resolutions of Parliament, but none of those resolutions can or has taken away the underlying rights which enable the process, because that process, being a process of the House of Commons and being a process of government, cannot be affected or intervened in by the police. They're not allowed to, because it's a higher authority and jurisdiction process. And it does explain that. And the only reason Parliament's there is because a Parliament's been called and MPs have been elected. But every single process that goes through Parliament has to be covered by privileges, or there's no facilitation of the process. There's no enforcement of the process. By saying that the Petitions Committee website and its processes are not covered by privileges is saying that it can be stopped, blocked, or intervened in, which it cannot. And the process does extend to put all persons engaging in that process access to the website to sign, mentioning it to other people. It cannot just be click the buttons on the screen, because, it is a petition, and the the basis of the petition is to share and collect. It cannot only be shared online. It says share this petition, but it doesn't say share it online only. It's got some options or suggestions: Facebook, email, Twitter. Now, I used the example of Lord Blunkett. Lord Blunkett is a Lord Peer, but he's blind. He had an accident at the tube station recently, right? If you've got a group of blind people, right, you cannot stop them or prevent them from signing that petition. And if they can't see the screen, then, you've got Speak Aloud. You've got the Speak Aloud feature in the browser, or they might have a braille or something. But a person has to be able to tell them. A person must be able to tell them or voice it to them. If there's some blind people in a room, you have to be able to translate and convert it into speak, which is, would you like to sign this petition, or how do I do it? Well, it's on the website. Well, I'll come and help you, or can I fill it in for you as a proxy with your permission, or so forth. You cannot say that blind people don't have a right to sign that petition online. And you can't say, therefore, that only blind people can have it spoken to or said to, because if there's other people in the other room, we're not robots. We're not relegated to only communicating by clicks, because that's what they did on Doctor Who on the episode when they had a pirate ship and they had like one of the villains had like a device around his neck and he couldn't speak. All he could do was talk through this device. The device talked for him, like Dr. Theopolis on Buck Rogers, with Biddy. You have the mouth to share it, when there's someone in another room and you speak to them. And that's, I just want to actually pause it a minute. Now, this highlights it exactly. When anything is for the purpose of government, right, or anything to do with any process of Parliament, you are using any material at all whatsoever that is printed, or even it says digital. It says in this act, right, the definition of an advertisement is anything that is illuminated or digital on a screen. It's in the Parliament Petitions website. When you open it on your computer, screen, it is an illuminated advertisement, which is under the Town and Country Planning Act advertisements. It classifies as an image, word, letter, sign, or a representation. Now, that's a legal representation, right, in any law or process. So, if you open a file with that if I've sent you a writ from Lord Hanningfield's case that Jeremy Johnson KC did in Southwark Crown Court, that's a representation. Now, if you open that on your screen, it's an illuminated representation. It's a legal representation, right? Which is what the petitions are. And that definition actually covers the act when you're sharing the things. So it actually legislates in the Town and Country Planning Act 1990 and 2007, or 1991, I think it's 1990 and 2007, that the definitions include any sign, word, letter, whether or not it's on a screen or illuminated or not, and also legal representations or legal process being showed to people or displayed. For example, a witness appeal is a legal representation, could be on an illuminated screen at a witness appeal, right? That's a representation. And really, when you're signing these petitions, it is an appeal for people to sign on their oath, really. People who support a cause, they have evidence that that cause should be acted by government, and they sign it to put they're putting their own evidence and opinion to it. That's what they're doing. And this Class F materials, it says you can apply absolutely any enactment to it. It says any enactment. That means that you can apply any enactment to it. So I can apply, what would you apply when you're doing a petition? If it's a petition, which is the material, whether illuminated on a screen or not, or whether on paper, right? What act of law would you use and apply if you can apply or use any? Well, you use the right to petition because you're petitioning. If you're petitioning, right, you use the right to petition, which has provisions that you can't be arrested or prosecuted for this. That's what the law is for petitioning. And that's why it's in the Constitution of England. Why else? Now, if there wasn't a parliament, like sometimes we don't have a parliament in between sessions, you have to do it to King and Council because there is no parliament and the Lords aren't assembled. You have to do it to King and Council because there isn't a parliament. And when there is a parliament, we don't need to go to King and Council because Parliament are there as a facility alternate. And we've got elected people who are in there doing the petitions committee. But it's still the King's government, His Majesty's government, and process of the King, just like it explains in the early Magna Carta, that when you write a complaint of a criminal offence and get a sheriff to seal it, it's a seal of the King. It's been sealed by the King's seal, right? That's what it explains that in the very first volume of statutes, which I've got. And I sent you the screenshot for that. It explains it. So, and also, if you've got, what I need to explain to the Speaker is this: if we've got an act which covers, explicitly it says processes of Parliament, in Class F, it's concerning and related to any process of the Parliament of England. Any process of it. Well, Petitions Committee and running petitions is, right? And it says any advertisement connected to those processes, which is illuminated or not, or on paper, you can apply any act to use it. Well, that means that we've got a legal right to choose any act which might be relevant or applicable to what we're doing. Well, that means that you can apply the Parliamentary Papers Act 1840. You can apply the Parliamentary Papers Act 1840 to the representations, whether they're illuminated or not, or whether they're by word of mouth or on paper. Because in the Advertisements Act, it also means it can be a model or a sign, which means it can be sign language or a model, but also a representation, as well as being like a legal argument. It also has provided for that it can be like you could be making a representation when you even do sign language, like, you have an interpreter, that's a representation, okay? Because they're making a representation in public and translating someone's speech into a visual representation, which is sign language, right? So, like a theatrical display does qualify for a representation. So, this is the thing. It is all covered by that. Now, the petitions have got the Crown stamp on them, and they are authorised to run by Parliament. It is a process of the Parliament, right? And you get the Parliamentary Papers Act covers all the button pressing and sharing of that petition, but it cannot restrict it only to pressing a button, because otherwise you are restricting a process. You're making us into like Dr. Theophilus that's hung around the neck of an android. Like R2-D2 can only plug his connection into the wall in Star Wars and work through a connector, which it cannot be, because an advertisement has to be convertible or interchangeable to pass it on and communicate it for reasons that I've said. Otherwise, you can't tell someone next to you that, oh, do you want to sign this as well? It means that you're only parliamentary privileged to press a button, but not to say to the person next to you, do you want to sign it as well? And you can't do that. You can't remove the privilege because it's the format is changing. We are covered for. It says you can apply any act to the material. So, and what I want, this is the act that I want to raise here. This is very important. Now, this is legislation that the government have written and the government have put out. Now, this particular act, I do admit that this is the local government, England, local authorities, conduct of referendums regulations. I admit that. I admit that this act here is the local authorities' conduct of referendums, right? Now, you probably might want to argue that, oh, it must be only referendums and nothing else. But by the way, this petition that's running now, for example, a different example, on the government website now, there is a petition running that is calling the general election. Now, if that isn't in connection with an election, I don't know what is, right? That petition for calling a general election, it is pursuing and in connection with an election, right? It is pursuing and it is in connection with an election, that particular petition, right? So this act here, the conduct of referendums and regulations and authorities, but also includes elections, they've got a definition and meaning. And it's the word publish, okay? It might say, in this act, publish means this, okay? And publish has to mean that through all referendums and elections, because if it didn't extend to this meaning of publish, they wouldn't be able to apply that meaning, and they wouldn't be able to conduct referendums, they won't be able to conduct elections, because of the reasons what I've just said earlier, which are that people won't be able to talk about the elections under the particular privileges and law of that election. People won't be able to go about doing the referendum because the meaning of publish wouldn't extend far enough to facilitate you being able to do it and it being enforceable and preventing, for example, the police intervening. Like under the Act of Law, the police have got like the canvassing elections. Police aren't allowed to canvass elections or referendums or intervene in the process. And that's why this meaning of publish extends so far, to be ordered to fully protect all of the processes and facilitate them and everyone engage in it without obstruction or intervention. And that has to be the same for the petition process, because the petitions are process. They're submission of writ and return of writ and the fulfillment of that process and the enforcement of that process. Now, this meaning that I've got up for publish here, it has to mean the same, but you cannot. There isn't really that many acts for petitioning. We've got the Tumultuous Petitioning Act. I've been looking for them. We've got the right to petition. There are very few acts which facilitate any meanings of words at all in petitioning. In fact, that's the reason that those acts of law in the Statutes, Volume 6, I'm saying that those 4 or 5 or 6 laws which I've raised and presented, which were enacted immediately following the 1688 Bill of Rights in the preceding years, there's very few acts released in general. Each one of those acts is ingeniously um, covering a subject which is actually relevant or kind of used in the petitioning process, like the gathering oaths of people to the petition, or having to investigate something, or the part that says, why would prosecutions be illegal and why all of them? Because you were pardoned for acting for an important matter. The basis, it's out a legal basis, which in modern law, people are saying there isn't any basis for all petitions being illegal. Where is that basis? Well, I found it. It's a legal basis in a law which codifies it, right? And so forth. So, actually, even the paper itself, the paper being sealed and sent into a process which eventually might be put before the Speaker of Parliament and put a stamp on it and be given assent if you submit a bill to Parliament to be put into law, that part of it as well, parliamentary, it's actually talking about government papers, not just parliamentary papers. It's actually an act. Funnily enough, the other act that I've cited for 1689, I think it's 1694, sorry, is it's government papers, like any paper that's for a court, any paper that's an affidavit, any paper that is a postea, any paper which is an order from a court, any paper which might be destined to have the seal of England on it, or sent to try and get the seal put on it, attempt to put it through Parliament, try it to be put through Parliament, or whether it succeeds and gets put through. All of those different papers are covered, not just like in the Parliamentary Papers Act, one's for Parliament. Could be for a court, it could be for the Sheriff's Office, it could be for the Supreme Court, it could be for the King's Privy Council, right? But when we're running petitions through Parliament, it is for the House of Commons. So it's parliamentary papers. You could say that the Parliamentary Papers Act doesn't apply if, for example, Parliament was prorogued or in between sessions, or if for some reason they didn't have a Parliament, you couldn't use the Parliamentary Papers Act. So what would protect the petitions or facilitate the petitions being processed without intervention, without a Parliament? How could those papers? Well, it would be the right to petition the King, and all prosecutions and commitments for doing so are illegal. So you don't need privileges of Parliament at that point, because you've got that as a fallback plan, and you've also got that Bill of Exemption, which if it ever comes down to it, even if it's a dispute with a sheriff, or even if it's a dispute with anyone, if it is legal process, if it is any writ of return through any process of the king or his kingdom, right, and there's going to be any dispute, it's either going to come to Parliament, or if you don't have a Parliament, it will be eventually, inevitably, to a court, and somewhere along the lines, a judge. And if he doesn't agree with you on your dispute or matter, or your law, on point of law, or a right you've got being the law, then you can use that Bill of Exception, and you can you actually summon that justice to the king himself, and that is ultimately your right to petition the king over anything that will be due to or destined to go through any due process of law that you could have in the whole country, ultimately, because they're always destined to end before a judge. And if you dispute the judge, then it's going to go to the king. And that's the basis of what I'm talking about petitioning Parliament, Now, let me just read this out, because I really didn't want this video to be long, because I know it puts people off listening, and I don't want to have people to listen to it and pause it. Hopefully, if I've spoken clearly, even in the Yorkshire accent, hopefully, like the Google bots might scan it, and you can put the words on the screen and have the subtitles, so the words come up, and you can actually get a transcript of what I'm saying now is available in text or writing. That's another right, you see, the right to convert between me speaking now and it being converted to text. So, like, your office might want it on paper, not me speaking now, right? And that's a little bit like the argument you're trying to make of, just clicking buttons on the petitions website, or whether you can actually voice it to people with your mouth and not just click a button. Even if it's not going to be a paper petition submitted to the government. Someone might not have a computer, but they might want to sign it. Someone might not have an email address. There's actually, and this is yet another thing now that I can raise up. I can raise this is a very legitimate argument. The Speaker cannot rebut this, and if he did, I would have to put a bill of exemption to the Speaker and summon him before the King. And this is this point. This is on a legal point, right? What happens if a person doesn't have an email address or social media, but they've got a right to sign that petition? I believe that they can write out the petition number, like, whether it's this call a general election one is petition number 700143, right? It's petition number 700143. If you said to someone, I'm going to write on a piece of paper, call a general election, right? And this is Michael Westwood's petition, and it was started on the 20th of May, 2025, and it's running through government. You could sign your name to it and write your address on it and your telephone number, and you can write the petition number down, which is what the number that I've just said, 700143, and you can sign it and send it into the petitions committee by post, and they can enter. I'm sure that they can add it to it. And the reason why I believe that's possible is because when Theresa Villiers was in a petitions committee having a debate over ULEZ, they were debating two petitions together with two different petition numbers. They announced that. They announced this debate is concerning two different petitions. So that's an amalgamation process which is set out in the Local Government Act and other acts to do with petitioning. It says that they can be amalgamated, and they did amalgamate them in that Gareth Johnson MP and Theresa Villiers, and also another minister, a third minister, he also voiced and gave evidence of a third petition which also ran. So they actually were, all of the signatures, which were separate, were given as evidence in that committee. Even if they were online, they were separate petitions. Now, there's no law in England and no standing order and no resolution, I don't believe, and no legislation or statute which can stop a petition being debated which has got evidence from digital online petitions or handwritten ones. Theresa Villiers could have as much as presented a hand petition she'd collected herself and two of the online ones, and the other gentleman do a third online petition, and they all could have been presented as evidence in that committee meeting. Whether or not they entered it into the system through and put his signature on the system and just put an extra number on it, or whether they amalgamated it separately or not, because I actually think that they probably print some of them out anyway. When the petitions committee have a meeting, it's likely that it will be converted to paper anyway and printed out, even though it's a printed version of the online. But that immediately then it becomes a paper petition. It's not a digital one anymore. It's a digital petition that's converted to paper, and other petitions can be presented. It's evidence-based. The signatures are nothing more than evidence. It's an evidence-based system. The signatures are evidence of public concern and support. I've mentioned this before. It's exactly like the Inquiries Act, Section 1, A and B. An inquiry is run either on, it's called due to physical evidence and facts, or on evidence and weight of public concern, right? And that is what you write in a petition. The petitioner humbly showeth. They can write a statement. They used to be able to annex evidence, humbly showeth evidence, or they can just have a very large amount of signatures. It is the exact same thing as the Inquiries Act requirements. It's just written down a little bit differently, but it is the same. An inquiry, a public inquiry under the Public Inquiry Act 2005, I think it is, the Inquiries Act 2005, which updates the Tribunals and Courts Act. It's a big inquiry. Really, all of the standing orders of the petition committee and the subcommittee appointed by the petitions committee, and those powers given through standing orders of the petitions committee, whether it's standing orders 145A3, right? They give the petitions committee very similar, or if not the same, powers as a inquiry. But they can only do small inquiries because it's only small committee. If it's a very big matter to investigate, that's why you use the Inquiries Act, and that's why you appoint an inquiry and a board to investigate a very big thing like the Hillsborough disaster, which is too big for the Petitions Committee to investigate itself. It's getting a very big inquiry going to establish facts, to find out facts for Parliament. It's just like a very, 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 very big subcommittee, which is temporarily set up using the Inquiries Act. It's only like a small subdivision of the Petitions Committee, but it's like you are temporarily creating a huge subdivision. Really, that's effect. I'm not saying that is precisely what it is, but it's enough of what it is. Yes, it's got its own law, it's got its own legislation, but it's comparable enough to be a similar process, just with slightly different laws. It's evidence, and the inquiry is evidence-based. It's an evidence-based inquiry. It's a process, and there are certain powers there. It is controlled and orchestrated. But this is the thing with the petition. Parliament are trying to make out that we can't orchestrate or process our own petition. If you turn up with nothing, you have nothing to write. If you have no information or no facts or no knowledge, you can't write anything or draft any petition, And then once it's been created and lodged, particularly on the website, which makes it very, very official, more than if you're doing one in paper, Parliament want you to collect more evidence of public concern. It's like there's no doubt whatsoever that it's like saying to the police, we want 2 million fingerprints, or we want 100,000 fingerprints, or whatever. Why would you need so many fingerprints? Because that's what they're asking for. Parliament want 100,000 signatures. They could have one signature, they could have 5 signatures. They're asking for 100,000. That is a body of evidence which everyone has to go out and collect. We're being instructed like little police officers to go out and collect lots and lots and lots of evidence. And how do you do it? You have to go around asking people, I mean, even Keir Starmer just made some, I don't know if it was a joke or serious, that he's going to send the police around to everyone's house who signed that petition, which is a joke. He might as well have the police going around asking everyone if they wanted to sign it. Is that illegal police canvassing? This is the thing. Is that the government, trying to influence the outcome of the petition when it's not come to its conclusion? This is the thing. But anyway, I want to come back to this. I still haven't read this out, and it's really important to read it out. It says, to publish. I want to kind of start fresh here and just kind of like start. I really want to concentrate on these 1 or 2 sentences here in this definition of publish. And that is, to publish means to make available to the public at large or a section of the public in whatever form and by whatever means, right? That means that there is no restriction or limitation or definition applicable. You cannot apply, you cannot restrain or constrain what form and what means are going to be regarded under the term publish, right? It means that when you use the word publish, it means in any form and whatever means you want, as long as you're somehow making it available to the public or a section of the public. And this is exactly what we're doing with the petition, right? On the website. You're making it available to the public, right? Or a section of them at large, in any form or by whatever means. And this is a definition and term which the government have come up with and used, and they want to be the law and the legal definition of that term, the word publish, for their process of parliament, for process of government, for things like elections and referendums, things where you have to go let people know about it. You have to go collect signatures or votes in some form in a process, right? And that is exactly what we're doing on the petitions website. It's a government process, and it's collecting, whether you want to call them signatures or votes, right? In process of Parliament. So it would be very, very, very unlikely or difficult to argue that the definition of publish, how the government have legislated that word and what they want that word to mean in their official processes of things like elections and referendums, and this petition is calling for a general election and pursuing one. This particular petition on the website that's got 2.8 million signatures now is pursuing a general election. It's actually in connection with one. So when we share these petitions and make them available to the public, right, and it went through the publishing of this website, it cannot only mean that I am going to click a button and then republish it on Facebook, or I'm going to click a button and republish it, send it by email, or publish it on Twitter. It means that I can make it available to the public or a section of the public by any form or in any means. And that is the exact same basis of if I say to my mum, do you want to sign this petition? Or will you sign this petition? Or if I walk out the door and I go to the shop and I say to the guy at the garage, have you seen that call a general election petition on the website? Have you signed it? And then he said no. And I tell him, I can tell him that I can tell him the internet address, https petitions.parliament.uk/petitions and then 700143. Or I can say the words to him, go on to Google and type in HM petitions and just type call a general election, or go onto the petitions website and you'll see it. It's like it's ranked as the top petition. You'll find it on there. I'm saying those words. I am therefore making that petition available to that person because it's not available to them if they're not aware of it. I make it available to them when I tell them that it exists and say it's on the government website, So it has to be, or you cannot make it available to blind people. You cannot make it available to people who might not be able to, do other things. you know, and so forth. I don't really want to get too much into disabled examples, but you know, how can you make the petition available to someone who didn't have any arms or legs? They can see it and they can read it, but they won't be able to sign the petition. It's not a very. I don't like this example, but if a person didn't have any arms or legs, which is very upsetting and traumatic, but if they did not have them, they would have to sit there and maybe they could use their mouth or I could do it for them. That is making the petition available for them to sign by any form and any means or by another person. What happens if someone didn't have I don't want to get into other laws because you have the capacity for people to even read it. What happens if someone can't read, right? This is another example. What if someone can't understand the law or can't understand the rights? I'm having to try and make the rights and the legislation available to people who can't understand it or don't understand the right when I explain it by making the knowledge of the right explainable to them by decoding it or by clarifying it or by thoroughly explaining it to them, you know? So it's the you're making it available to someone who couldn't otherwise sign it. And also if they couldn't read, right? If someone says, I can't read this writing on the screen, right? I cannot read, okay? If you get a person who can read, okay, you could say, please will you read that for me? And then you would read it to them. And what happens if you're lying? Well, you have to do it you have to say on oath, you know, you say, well, this is what it says, you know. It says call a general election. I would like the government, you know, to have another election. Because I think the Parliament have gone back on what they said. So, and then they could say sign it, and that person still might be able to click the button and type the keyboard, but they might not have been able to read the writing if they haven't been taught how to write. I know you've got to explore these. It has to cover every possibility. You know, they might not be able to read, so I have to make it available to them by telling them what it says. Although now on the internet they've got that speak aloud thing, which you can press that. But if Google didn't have speak aloud, they might not have a browser that's got speak aloud on it. I don't know if Firefox has speak aloud or whatever. This is the thing, right? So it is to make available to the public in any form or by any means. So when it is the Stop ULEZ cause, right, you are allowed to tell people that there's a cause with the Parliament that is Stop ULEZ. And that is what Theresa Villiers herself was actually doing. She actually did have a similar protest and everyone actually started copying off her. Theresa Villiers even said she arranged it, and she's an MP, and she's making it known and available to the public, and that's what everyone started copying off her and doing. So they were continuing the work of Theresa Villiers, really. Maybe they started before her, but she definitely set she exemplified part of the process. So the Parliamentary Papers Act, the word publish in that act under a government process of Parliament does mean to publish means to make available to the public or a section of public at large in any form or by any means, right? And that's a government definition of publish. And you can use the right to petition, and you can't be prosecuted or arrested for that. And the only reason it says it's the right to petition the king is because in 1688 they didn't always have a parliament formed, and no one had parliamentary privileges when there's no parliament, right? It didn't exist. So you can't be arrested for prosecuting the king or imprisoned, or else you can't collect the signatures or the evidence in the process. And then when they call the parliament, you don't need to do it to king and council. You do it under Parliament privileges through the committee. And you don't need to use the right to petition the king because you're doing a process through Parliament which gives the essentially similar or the same privilege as the right to petition But ultimately, it's still the king's process. It's His Majesty's government. It's the realm of England. It is that's what it is. And this definition of publish that they've got in the Local Government Act England and Local Authorities Act, I can guarantee you that that definition of publish applies for not just local government. That definition of publish applies for the actual Parliament as well, because they used it for local government because they've copied the same meaning and basis for the word publish. So you can, through the Town and Country Planning Act, when you're doing something with a parliamentary process, it's almost as if Parliament and the Speaker believe that there isn't anything in the Town and Country Planning Act that is a parliamentary process, or somehow to make out that, petitioning over Stop ULEZ isn't a parliamentary process. That, as it explicitly says in Class F, they've gone out of their way to say when there's any process of Parliament, which anyone can engage in or what exists, or whoever can engage in it, there are processes that people can engage in for Parliament, and there are processes that people can engage in for Parliament. Parliament can't say that, all of the processes that the public can engage in have got Parliament privileges, and all of the processes that the public can engage in for Parliament don't have Parliament privileges. Well, that is extremely selfish and bigoted when it's a Parliament process. Parliament processes need privileges of Parliament because they're a very serious, important parliamentary process. Not down to who's allowed to engage in it or not. The public to engage in this process because they've got to collect the signatures. They're told to go out and collect 100,000 signatures, just like a policeman sent out to collect 100,000 fingerprints or 10 fingerprints or 1 fingerprint. This is the thing, right? That's the point. Which I'm going to go back to. I've covered this, the meaning of public in law, particularly in government law, local or central government law. In central or local government law, the meaning of publish means to make available to the public or a section of the public by any form and by any means. Okay? Or else you wouldn't be able to do the process. It's a no-brainer. It covers all of the things that you need to do for these processes, which is tell people about them and go about collecting evidences and making copies of documents to show people or tell them about certain things or share. That's why it says that illuminated devices in the definitions. The definitions cover digitally illuminated screens and devices like your computer screen. It includes that. It's not exclusive of anything else. The advertisement term includes all of them. And the word publish includes all of them. And it is a matter of Parliament. So it is a parliamentary document and paper. Now here, this is another important part of this. This is another part that kind of like is eventually I want to, this is my last point now, but this is eventually how it relates to people being on the streets and voicing these petitions or sharing them by leaflets and paper, which is not a protest under the normal law and legislation, because a protest under that law, which is not saying that you have any other rights, it is all and every situation where you've got people protesting or picketing against their employer or against a media outlet or a business or a music stadium. There are thousands of situations where people can be protesting, which isn't a government process which they're engaged in. You're not engaged in a government process when you're protesting to be let back into a rugby match. That's the thing. So the government have been very misleading in the legislation using the word protest in the law, because it's separate to when particular rights and privileges come into play, come into force, which are when you're doing a petition to the government. And all we're arguing is that you can't be arrested or put in prison. I'm not arguing whether or not people can or cannot be removed from an area by the police if it's for their safety, similarly to how children are dealt with in the Act. It's a very important point, you know. Children are privileged at that point from that act of law, you know. Now, my battery's going to go in a minute and my coffee's gone cold, and I want to try and go somewhere before it closes. I have to plug the battery charger in. So I want to talk, the last point I want to talk about, and I know this is a very, very long video, but this is the Parliament of England. This is the Speaker of the Parliament of England and his staff and all possible future processes and applications. So you can't really get any more serious of somewhere to submit this appeal which I'm making, and this evidence which I'm making now. And that is this, that Royal Mail, okay, only became available to the public in 1635. So Royal Mail was only available to the public in 1635. Before that, it wasn't available to the public. There might have been, you know, horsemen or couriers or whatsoever acting independently who you might pay like a gentleman to deliver a letter somewhere for you. But Royal Mail was only for the government, the king, okay? So before 1635, so in the 1620s, Royal Mail was only for process, right? It was only for written return. So some of those petitions that I'm reading now from the National Archives, which have been transcribed by Dr. Brodie Waddell and his team, those people, some people were in prison, some people were going to court or so forth. Now, in the 1620s, when people were petitioning Parliament, and they were submitting petitions to the House of Commons or to the House of Lords, or if there was no Parliament, to the King and his council, how does the letter get there? The letter gets there by Royal Mail, okay? It delivers letters to the King, or delivers letters from the King to persons. So you would get, you know, if you had a letter from a court, you would get it delivered to your house. Now, back then, they had a lot more notice boards, right? So, like, courts would have lists up, or town criers would make proclamations, or they might have notice boards with certain things up where people go and check, you know, and so forth. Or you might go collect it. I'm not saying that they came to your house with a horse. You know, there might have been a royal office, like the sheriff's office, or something like that. But if you writ a petition to the King, it will go by Royal Mail. If you writ a petition to the King when there was no Parliament, it will go by Royal Mail. That's a process. And if there was a Parliament, then it will go to the Parliament. Okay, if they were holding a Parliament, it will go to the Parliament, or you could even give it to your MP, but you could send it, because Royal Mail was for all process of the King's government, right? Now, that means that sending and receiving petitions, right, is royal process. It's process of the King. It's Royal Mail. When you writ a petition, whether you were in prison or not, or whether you weren't in prison, to the King and his council, it was delivered by Royal Mail, because that's the process by which you send and transmit it. Although you can actually present them yourself in person. If you're in London, under the 1661 Tumultuous Act, people had the legal right to present them themselves. If you live far away, then you would send it because it was too far away to hand it in, right? Or the sheriff probably ran the Royal Mail system, but this is what I'm just getting into looking at now, how it worked. I think they had specific officers for it, right? But the framework of it is process. It's king process. That's why it's Royal Mail. It's the king's process. Even if you hand it in to him, you're delivering it yourself, right? This is the thing. So after 1635, when they make it available to the public, then you could pay to have letters delivered, and not just to the king. You could actually then, it was only then, at that point, where they added in to king's process of justices mail being sent and received and delivered. Although remember, like I said, they had a lot of notice boards and a lot of town criers and it was a lot more social order, like point of, like polling station type of point of information, point base. But they did have, you might get, if it was important matter, you might get them delivering a letter to you directly, right? So this is it. They added in the public to the king's mail process, and you could then, not just every single citizen sending a letter to the king or getting one back, or getting it back at the local office or whatever, the local point, the local information point, or even through the town crier. Could have even been the local alderman and council where they sent it to, and then they might have had more local people. But whatever network they had, it was all king process. So that's local aldermen, council, courts, justices on their circuits, the network of king and his government, but not for the public themselves, between each other. Always subject to the king, or king to the subject, or between the king's officers, but not the public to public, right? So after 1635, Royal Mail becomes subject to subject, okay? Subject to subject. Now, that's just me writing a letter to my next door neighbour, or, if I'm lazy, or to someone in another village, or someone in Portsmouth, or someone in, Plymouth, or whatever it is, or someone in Berwick-on-Tweed, right? I could get a letter delivered to them. But the origin, what is Royal Mail? What is Royal Mail? It's king and king's process. It's writ, issue of writ and return of writ in process, right? And for petitions, they're evidence-based on statement, evidence-based on fact, and evidence-based on oath, on witness signatures, right? It is an evidence-based writ and return process, which must have it has to have activities in the sphere of paper, or else a police sheriff cannot. Police don't exist on paper only. They have to go get evidence or find out knowledge and apprehend people, right? If you don't have any knowledge or information, it cannot be transcribed onto the writ and then sent through the Royal Mail, the petition, and so forth. Now, so petition to either Houses of Parliament or the King and Council that's king mail, king process, regardless of whether it was before or after 1635. If it's a petition, that is king's mail, whether you deliver it yourself and give it to him, or whether you use his Royal Mail. And that's important, because when these petitions are running, it's king process. It's king mail when the website pops up on your screen. And that's why it's got the Crown logo on it. And this is like obvious. It's upsetting that we have to go through it all. And when you deliver it to other citizens or share it, that's king mail and king process, even when you speak about it, because some people are blind, or some people can't read, or some people might not have an email address, right? And that's king process. and it's king process as much as the police are going out to bring me 100,000 fingerprints or whatever, bring me 100,000 signatures, and there ain't enough police people to go about doing it. So, Starmer knows this. This is why I think he's made that, gesture of his, respect order thing that he's been going on about, threatening to send police around to people's houses who signed this petition. So, not that I can't see how they've got enough, as many of them, but this is the thing. So, sharing those petitions and speaking about them to the public, it is Royal Mail, it's King process, it's executing the process, and it clearly says in that sheriff's book that I've got, the complete sheriff book, and in the very first volume of statutes, when you type in the word petition, it explains that, anything with the King's seal, it is King process and King mail, and however you're sharing it. We're told to share this petition. It doesn't say share this petition online. It doesn't say only share this petition online. It just says share it, and it gives you some suggestions, which are Facebook, email, and Twitter. It cannot be unlimited to those. If it were unlimited to those, it would be heavily restrictive, and it isn't restricted to those processes. And any process that you use to talk about it is protected, and that's why it says under the word publish, for what it means in law for local or central government, to make available to the public in whatever form and by whatever means. And you might say, well, we're making it available in this whatever form or by whatever means. But it's for everyone and everyone. It says the meaning of the word publish is when anyone uses that word. It says make available to the public in whatever form and whatever means, which is what the Petitions Committee are doing themselves, right? It is make it available to the public through whatever form and whatever means. And it's class F. It is a class F in law, and you apply what law is being used, which is the right to petition, and actually the Parliamentary Privileges Act. You apply the Parliamentary Privileges Act because it's a Parliament process. The Parliamentary Privileges Act is applied to any Parliament process, and Parliament kind of somehow want to make it not a parliamentary process. They wished it wasn't. They'd like to wish that it wasn't a parliamentary process, that government HM petitions wasn't the Parliament website. They want to defy the truth and fact because they don't really want the full and complete law to apply. Or they just want to say, well, when we use parliamentary process, we're privileged. When you use it, you're not. Well, we are. Anyone or everyone is, because the petitions are a written return process, and quite an important one when it's deciding whether there should be a general election or not, or how the country should be run, or what the taxes are. All of the terms are thoroughly present in law. There can't be any dispute or argument around those terms in law or definitions, I'm not saying that all protesters can't be arrested, but the people who made those acts, particularly people like Priti Patel, they're ignorant and undermining English rights, English political rights, which are not always used or enforced, particularly if it's sport or music festival or a dispute between employers and their boss. And there was a lot of shift in the miners' strike around terms and definitions, and if Parliament has to put a picket up around it, then that's what the word picket means, if they have to put a protective or defensive wall up, a picket line, the picket line is a protective or defensive wall. The picketers are not the actual miners who are striking. The picket line is the actual wall that protects or defends, So, and then if you want to talk about, people kicking off and things like that, all that's facilitated through the general pardon basis. Has got some examples of what things probably shouldn't be pardoned, quite certain or serious offences. But generally, if you're getting quite a lot of signatures of the public supporting what you're doing and how you're going about doing it, like Extinction Rebellion or Just Stop Oil, in a way, they're getting the consent. It's public consent. It's consent of peers, which is a Magna Carta basis on judgment of peers. And they made an act very shortly after the 1688 Bill of Rights, which had a codified legal basis for, if you get signatures of people supporting your conduct or behaviour, or condoning it, or saying that it's necessary, that constitutes towards a pardon. So that is a legal basis of why you wouldn't be prosecuted for doing petitioning if it was supported. And then also they've got the general pardon basis just on the merit of acting for your country in matters of state, important matters, which might be more important than local policing or crime. For example, stealing a loaf of bread. Getting the calling a general election, or, if you've got evidence that something's been a grievance against the government, for any reason something's critically wrong with the government or not right and needs to be corrected, then we've got a right to complain by petition about that with evidence that must have been obtained from somewhere or somehow. This is the thing, and Parliament is meant to have the petitions committee to deal with all this, but they don't really want to. They only engage with certain persons, like, Merlin Sheldrake, when they want him to go talk about mushrooms or whatever. They're fascinated about mushroom discussions. They probably don't have the facilities to. If it's a very serious matter and people get the signatures, then they can hold an inquiry, and then, the inquiry will direct further evidence. But you've got to have some kind of initial evidence or substantiating facts to merit anything. But at the moment, the weighing scales are heavily on the side of signatures and not fact-based, evidence-based. In fact, it's restricted in how many words you can write and what links you can put. They don't let you put links half the time. And then they say we don't understand what you're asking when they've restricted the words. So it's excessively restricted in evidence base, even statements restricted, in order to, why should people sign it? Maybe they don't know why they should sign it, because you don't allow them to show why. It's excessively over-sided to evidence of public concern merely by oath and signature, not actually by anyone adding any more evidence, assisting with inquiries, helping find more evidence. A lot of these cases will be proved. It could be the fact that the reason why that, people are complaining that there's corruption in the government, things aren't being doing right, and that we're being obstructed from resolution of it, is because we're being prevented from. And all of the separate complaints, all of the separate government departments that have complaint letters in, no one sees them except government staff. And they've been trained and organised to file them and put them away or deal with them. And if there were more complaints that were signed by multiple persons, were contributing evidence towards it, then they would be challenged and a lot more liable to do something about it, or change their procedures, or conform, or even, monitoring officers, or the Privileges Committee, or the Ombudsman, if there were more group litigation style petitions where not only than signing it, people could say, well, I've got some evidence that could prove this, or I know this or that, then the people would have very powerful and compelling cases by petition, which many MPs probably would not like to read out or not want to have to deal with. But there would be a lot less corruption or faults in the government. But the government are claiming there isn't any. This is the thing, they're in denial. They think that the government is perfect or works like clockwork and nothing's been done wrong. The whole point of petitioning is a grievance and challenge to the king or government over these matters, whether it's getting a law made or changed, or taxes changed, or whether it's a criminal complaint, usually through local areas for the police. But it can be where it's so serious or important, where, I mean, usually because the police can't arrest live peers, that you never would have gone to the sheriff really about like Lord Moon. Lord Moon, you had to petition Parliament or the House of Lords about Lord Moon's behaviour and get permission to prosecute him, and it had to be in Westminster because he couldn't be prosecuted in a local regional area. There's loads of arguments over Lord Moon's conduct and behaviour. You had to prosecute him in Westminster or Parliament by his peers, but you could complain about him, you know, and people could petition evidence and write in and send evidence. It's like group litigation, and really, people should be able to petition local councils about that, and we're being prevented from doing that on the government website because apparently it wants to keep its respect and integrity. What Starmer's saying, that it wants respect and integrity, which is why we're not allowed to submit evidence or attach evidence or, you know, really put much writing. And then they're rejecting petitions saying they don't know what we're asking, which is an insult when they've restricted the writing of how many words can be put. So we are being undermined of the highest and most powerful process. We shouldn't have to go to the Supreme Court. It's the Parliament of England. The Supreme Court is only like the House of Lords anyway. The Supreme Court has only taken over from the House of Lords, and a lot of petitions were to either houses of Parliament, whether you wanted to put it to the Commons or the Lords. So just because the Supreme Court have taken over from the Lords doesn't mean to say that you can't petition Parliament. And like I said, I've explained the whole thing with the King, is that there wasn't always a Parliament. If there isn't Parliament, you don't have parliamentary privileges. No one has. No MP. So how can anyone exercise any power or authority pursuing a matter to the King and Council if there isn't a Parliament and no privileges of Parliament? Because it's privileges of Parliament, not just privileges. It is privileges of the Parliament. And when there isn't a Parliament, it's just King and Council, you know? You don't have MPs. So it's the right to petition the King. It has to be. I mean, and the justices, if you end up, you know, contesting any justices, that's what the Bill of Exemption was, to summon them to the King, any of the justices, you know. But you don't usually summon justices to the King. Justices are there usually to deal with crimes or tort law. Justices usually can't change taxes, but they used to be able to, the aldermen and the mayors, you used to be able to petition about taxes and the use of money in local areas and how much tax was allocated. And they had juries. They actually had juries at the assizes or quarter sessions that could actually make up decisions on how the taxes would be spent in the local area, and how much tax was raised in the local area. So those were petitions to the local courts or assizes with a jury, which they've taken that away from us now. It's completely controlled by the local council or building and planning permission. Yet those councillors, you can petition actually for a proper jury, higher. The local council with aldermen is only like the magistrates' court, and you might think that it's become the normal now. They always have a slot for petitions. You can petition anything you want in that slot for petitions in the local council. They've got 5-10 minutes where they have to hear petitions. It's a blank sheet of paper, as long as it's about the matter that's before the council. And actually, there's nothing in the council procedure laws or rules that says that, well, I want this matter heard by the equivalent of the assizes, which is the Crown Court or High Court, with a jury of random jury of public, or petition Parliament instead. And that's all the way through up to the 1800s. you could choose not to have it heard by the local council, because on the petition presenting, you can petition for whatever you want because you've got freedom of subject. So instead of saying, we oppose this planning on this point or that point, or we've got a petition from local people, you could say, well, we want it heard by the King's Judge, the Assizes, with a random jury. We don't want it heard by the local councillors because they might be biased or prejudiced. Or you can say, we petition Parliament over this matter. And currently they're trying to say that you can't when you can. It's clearly there. I've just been reading some acts from the 1800s. You can petition Parliament on loads of matters of a local council, or ask for a jury, the quarter sessions or assizes, and not to be heard by the aldermen, the jurats, the local councillors. They're only like the hundreds court level, the local councillors, and there's only a lot of them because there's a lot of areas, right? There were only 6 or 9, right? There's only like loads of councillors because the towns have grown. They're not a high level alderman, councillor, jurat. It's not. When you go to the King's Court, the assizes, the quarter sessions, you get a jury of random local people who represent the local public opinion, and that's actually going higher than the 100 magistrates court local councillors. The local councillors are only equal to the lower level. When you call a jury in, you're actually going higher. That's why Crown Court's higher, or to Parliament. And you should be able to actually. It's not in the local council rules. They've got local council rules where they say that you effectively can petition about anything and create up your own process or rule and get it passed and put into action. Like how to have a local referendum in a local area, or in a ward, or however you want to design it, and they can approve and authorise it. You can have a local ward referendum by your design and approved by the council, and then it only costs £800 for a polling station. If you want to, it's a referendum. The Secretary of State can authorise that, and the only reason how is it asked the Secretary of State, you must have petitioned Parliament, because the Secretary of State is House of Commons, Parliament. How do you get a local referendum from the Secretary of State? Is by petitioning Parliament. And then the Parliament petitions website are trying to say that we don't do petitions for local government, or you can't. Well, you can, because the Secretary of State is the one who grants a local referendum on the matter. And the Secretary of State is in the House of Commons. So you can petition the House of Commons for the Secretary of State to give you a local referendum on a local matter. And if you petition the House of Commons, anyone who's got an interest in it, you're appealing to the rest of the country to help you petition for a local referendum. They're not going to vote in that referendum because only the people who live in an area are going to vote in a referendum. How do you get a referendum? By petitioning for one. You've got the right to petition the King. Everyone has in the country. There's no law in England that says you've only got a right to petition if you're in a certain county. None at all. You've only got a right to vote in an election or referendum in a certain county, but for a petition, that's different. A petition can obtain an election or referendum or trigger one. You're only trying to trigger it. All of the people in England can sign a petition on the Petitions Committee website to trigger a local referendum about building some houses if there's enough interest, and the Secretary of State can grant it to the local people, and then those local people can have a little referendum in a ward. And it says you can only have one referendum a year, but that one referendum per year where? One referendum per year in the county, one referendum per year in a ward. If you had a referendum in one ward, then you won't have a referendum in another ward. So that ward maybe can't have 2 referendums a year. But this is the thing. All these things are currently possible in the current legislation. They are possible in law. And the petition process is quite open and free and long established. And because you've got that petition slot in local council with minutes, it's a blank page. You can ask for whatever you want. And it's in law that you can ask the Secretary of State, who's in the House of Commons member for a referendum. So why wouldn't you ask him for that through a petition? Which, they're trying to block and stop things that you've got a legal right to have, which actually are done by request or petition, And this is what's annoying about all the building and planning. People are panicking that they're not getting any help or assistance. And actually, a lot of these green groups and greenbelt groups and local groups who are quite small could potentially be getting a Secretary of State to grant more local referendums about these matters and let the public decide themselves, which is in law. There are meant to be local petitions, and they're also meant, you can have juries as well. It's all through the 1800s acts, and it's all by petition. All of these forms, a criminal complaint by an affidavit, the form of it's a petition. It's like the right on it's to the Lords assembled in Parliament, or to the local council assembled, or to the sheriff. I humbly showeth that. Put your evidence. We pray that what you're asking for, and then it's signed on oath. It is the same petition. That's why they call it a petition for divorce. I know there are slightly different rules and procedures, but we're talking about the ones that don't have any rules, or it's an open procedure. The Petitions Committee does not have extensive legislation around it. I've asked for it. They've only got standing orders, resolutions, and a little bit of statute law. They've got the Tumultuous Petitioning Act was repealed. There's nothing stopping us from doing these things, and it's been heavily restricted and undermined. And we're not getting our rights as well when we're going about doing these things. So those are the issues, and that explains every single point that has been contested, at least in the email replies. So, it's a long video, but, I can put it on YouTube and get it'll generate voice text for it, and then you can copy and paste the voice text and put it into writing if it needs to be written in writing. But, I don't want to have to sit there and write it all down when I can just speak it. So this is the complaint that we going back to the Parliamentary Papers Act. It must cover actually petitions and sharing them, because they're a parliamentary process. It's like trying to say that it's a parliamentary process, or we're not allowed. Privileges only apply to, privileges apply to parliamentary processes, not parliamentary processes that only MPs can engage in. And that's a fact, because we've got privileges all the way through the history archives of people using privileges. So you don't have to be an MP. Otherwise, the publishers wouldn't be able to be eligible to the privileges. Privileges is for a process of all it means is that it's an operation through Parliament. It's a process of Parliament.